Okay, so that water bill you get from your landlord every month, it probably feels like just another routine expense, right? But what if I told you that for thousands of people all across Massachusetts, that simple piece of paper is actually hiding a pretty costly and totally illegal secret?
It's a really direct question, I know, but the answer might seriously surprise you. For a lot of renters in Massachusetts, it could actually be a yes. So, how can you know for sure? Well, we're going to unpack all of this, and we're using a super insightful article from attorney Arthur Hardy-Doubleday to guide us.
I mean, listen to this quote. This isn't some minor technical issue we're talking about. This gets right to the heart of it. It's a really bold claim for sure, but it is backed up by some very specific state laws that, as you're about to see, are surprisingly easy for landlords to get wrong.
All right, so let's dive into the details. This is not some rare, obscure problem. We are talking about a really widespread issue that creates a messy situation for everybody involved, tenants and landlords. And a lot of the time, neither side even realizes they're in the middle of it. Just let that sink in for a second. Your monthly bill might be including water for, the common laundry room, or maybe it's covering the cost to water your landlord's prize-winning roses. The point is, it could be your money paying for water that you personally never, ever used.
So you might be wondering, how is this even possible? Well, it all comes down to the fact that Massachusetts law is incredibly specific about this. It is not as simple as a landlord just getting a bill from the town and forwarding it to you. Nope, there's a very strict, very formal process they have to follow. And this brings us to a really key legal concept. It's called conditions precedent. Now, I know it sounds super complicated, but the idea is actually simple. These are not suggestions. They are mandatory hurdles a landlord must clear before, and that before is the key word, before they can legally ask you for a single dime for water. No exceptions. This 5-step checklist, this is the absolute heart of the law. Let's run through it. First, there has to be a submeter that only measures your unit's water. Second, the landlord has to get an official certificate from the Board of Health. Third, you, the tenant, have to get a copy of that certificate. Fourth, there has to be a specific written water addendum in your lease. And finally, all your fixtures, your shower heads, your toilets, they have to be low flow. If they miss just one of these steps, the entire charge becomes illegal. Period. Okay, so now that we all know the rules, how can you actually spot a problem in your own situation? Let's look at some of the really common red flags that should make you, raise an eyebrow at your water bill. Just think back to when you signed your lease. Do you remember getting a Board of Health certificate? Or signing a totally separate document just for water? If your lease just has a generic line like tenant pays water, that's a big warning sign. If your landlord just takes the bill from the town and passes it on to you, that's another one. And if you ever see the word irrigation show up on that bill, well, that's probably the biggest red flag of all. Seriously, this is one of the most outrageous, but also one of the most common examples of an illegal overcharge. In a lot of towns, there are separate water meters just for landscaping, and some landlords just lump the entire bill together and pass it along. This chart right here shows you just how crazy it can get. Okay, so on this sample summer bill, that first bar is the water you actually used inside, showers, dishes, all that stuff. But look at that second bar. That's the water for the landlord's lawn sprinklers. In this case, you are literally paying more to water their grass than for all of your own water needs combined. It's wild. And hey, we're not just talking about a few bucks here and there. A few high summer bills year after year, it can easily add up to thousands of dollars in overcharges. That is real money coming out of your pocket for something you get zero benefit from. Okay, let's switch gears for a second and talk directly to any landlords who might be watching. Look, this isn't about pointing fingers, it's about managing risk. Just saying, oh, but everyone does it this way is not a defense that's going to hold up in court, and the financial penalties for not complying can be surprisingly steep. And here's why. Illegal water billing isn't treated as just a simple lease dispute. No, it falls under Chapter 93A, which is the state's very powerful Consumer Protection Act, and that raises the stakes dramatically. It introduces the possibility of multiple damages, and, get this, having to pay the tenant's legal fees. This table right here breaks down the potential costs. And what's so fascinating is that even for a so-called technical violation, like you just forgot to give them the certificate, the landlord is still on the hook for the tenant's legal fees. For an actual overcharge, it's a full refund. And if a court finds the violation was willful and knowing, they can double or even triple the damages.
That's where things get really, really expensive. So let's just do the simple math here. The cost to get everything into compliance, to do it the right way, is a one-time business expense. But the potential cost of a single lawsuit from just one tenant, when you factor in refunds, damages, and all the legal fees, can easily dwarf that initial investment. From a pure business perspective, the choice is pretty clear. Okay, so we've covered the problem, we've covered the law, and the consequences. So what do you actually do now? Let's get practical. Whether you're a tenant or a landlord, here are your next steps. For all you tenants out there, start by asking for the paperwork and do it in writing. Then dig up your old bills and look for those red flags we talked about. A quick call to your town's Board of Health can tell you if your building is even certified. Document everything, every email, every bill, and then talk to an attorney. A lot of them offer free consultations. And don't forget, if you win, the law says your landlord has to pay your legal fee. And for landlords, your very first call should be to your local Board of Health to get the ball rolling. Get the right submeters installed, no more splitting bills. Get that official certification. And use a legally sound water addendum for every single lease from now on. Getting into compliance proactively is the absolute best way to protect your business. And that brings us right back to where we started. That simple water bill sitting on your counter might be hiding a lot more than you think. At the end of the day, it's not just about how much water you use, it's about whether you're being charged for it legally and fairly. It is definitely worth taking a second look. You really might be surprised by what you find.